We're now on Unit 9, Law and Evidence. We're going to be covering legal issues, the nature of the legal system, difference between civil and criminal law, some basic criminal laws dealing with computer crime, and a little bit about investigation and forensics. One thing I really want to point out to you, though, with this unit, what I'm showing you here in this lecture is quite a bit different than what's in the chapter in the textbook. The chapter in the textbook, in my opinion, is very thin, doesn't cover a lot of this stuff in detail. I'm not sure why, because in years past, the CISSP study material did cover a lot more in terms of computer laws, laws against computer crime, etc. And now there's not a whole lot there, and I'm not sure what's going on. But let's go ahead anyway, and just keep in mind that if you go through the text, a lot of what you see in the text doesn't reflect what I've got here in this lecture. Here's an overview of what we'll be covering. Starting with different legal systems and types of law. One thing that's important to realize is, most of you may be living here in the United States subject to U.S. law, but it's very important as a computer security professional to understand that different legal systems exist throughout the world. Different countries have different standards. Many American corporations now have international operations. There's a very good chance you'll be working for a company that is in fact headquartered or does substantial business elsewhere, and you need to understand that there are differences between laws in the U.S. and laws in other countries. We'll get into a bit of the specifics of different types of information technology law, dealing with intellectual property, privacy, issues of employee monitoring and surveillance, civil liability, what can you be sued for, and so forth, and computer crime, some of the basic high-level federal laws dealing with computer crime. We'll then get a bit into incident response, and actually what we've got going on between computer crime and incident response involves some coverage of rules of evidence and when are computer records considered evidence or not. This isn't covered in a book, but I think it is interesting and essential stuff for you to know. These sections of the book we're covering is the Official Guide to the CISSP by Tipton, page 503 to 538, Laws, Regulations, Investigations, and Compliance, which is chapter 6 in the book. Here's a disclaimer. I'm not a lawyer. You probably aren't either. Don't pretend to be a lawyer unless you really are. And if you really are, it means you've passed the bar exam and you're properly licensed to practice law. Technical people really love to speculate about legal matters. It's okay, for lunchtime conversation or, after a few drinks after works and so forth to talk about what you think the law ought to be and what things ought to be crimes and what things shouldn't be crimes. But remember, you're not a lawyer. And speculating about the law when your company's interests or your interests are at stake can be very dangerous. You really need to consult an attorney, and one that specializes in the relevant area of the law. Don't talk to your buddy who does family law if you have a question about intellectual property and copyright, for example. A lawyer who practices in a different specialty isn't necessarily qualified to give you a good opinion on what another specialty requires in an answer. What this unit can do is help you identify issues and help you frame the right questions. It won't teach you to make decisions about what's legal or not. And remember, you're not qualified to make those decisions. What we will try to do is tell you what some of the issues are and some of the things you need to think about. So when you do talk to your corporate counsel or some other sort of legal advisor who is properly licensed and properly trained, you have some idea what questions to ask and what to deal with. Only a licensed qualified attorney can answer your legal questions. Technical people cannot, by definition. Don't succumb to the temptation to practice law, okay? Now let's talk a little bit about the different types of legal systems here. In the Western world, meaning the world that's been influenced by European legal systems, the bulk of Western Europe plus many of the former colonies of European nations, there are two basic types of legal systems. There's a common law system and a civil law system. Now, the civil law system, do not confuse that with civil legal matters within a common law system. There's a difference between the systems and civil litigation. The common law system is a heritage of the English legal system, of the law as it was practiced by the Anglo-Saxons in the Middle Ages. It is more common in former British colonies, including the USA, And it has a tradition of non-statutory law formed by centuries of judicial precedents. What is non-statutory law? Non-statutory law means something that's legal and enforceable, but for which there is not an explicit rule documented somewhere passed by a legislature, enforced by an executive branch of the government. Common law is formed by the tradition of judges' rulings over the century. Common law includes not just judicial decisions, which are often referred to as case law, but can include statutory law and administrative law. Statutory law is stuff that's passed by the legislature. For the United States federal government, statutory law is described in the U.S. Code. You'll see a U.S. Code citation for a statute, and that is a law passed by Congress that is part of the common law system of the U.S. You also have administrative law, which is law that is executed and decided by the executive branch of the government. The legislative branch says, okay, there are very complex technical issues that certain areas require regulatory oversight of. We're going to create an agency, and that agency will be responsible for that oversight. We're going to give the agency a broad mandate, provide for some accountability for the folks who are running this agency, but what they will create is called regulatory law. In the United States federal system, regulatory law is described in the Federal Register, which is indexed in the Code of Federal Regulation. So this is all part of common law. Common law consists of judicial decisions, case law, statutory law, which is law that is written by the legislature, and administrative law, law where the legislature has granted the executive branch a broad mandate to regulate and administer certain types of activities. Now, civil law is different. Civil law was influenced by ancient Roman law, and we can trace the origin of civil law on Napoleon Bonaparte. It's based on written codes such as the French Napoleonic Code. You tend to find civil law jurisdictions in places that are either French, influenced by the French system, or have deigned to copy the system. Under civil law, legislation and not the courts are the source of law. You don't have the rich source of case law that you have in the common law systems. You tend to have statutes that are very specific that tell you exactly what you can do. Civil law tends to be used in continental Europe, Latin America, and because we've got federal systems in the United States and Canada, the state of Louisiana and the province of Quebec tend to be civil law jurisdictions, or at least mixed legal systems with a lot of civil law because of their French heritage. Other types of law include customary law, which is described in the book at the bottom of page 509 in very, very general terms. I'm not familiar with what countries practice customary law, in what countries it is, a part of the code or part of the legal system and how it's enforced and so forth. I'm assuming that it is in countries that had a rich but perhaps not formal written legal tradition prior to European colonization, and after the Second World War, as they became independent, incorporated their customary law into their formal legal codes. According to the book, this is usually combined with some sort of civil or common law system. And then the other example given in the book is religious law. The book gives an exclusive example of Islamic law, which is, a religious-inspired legal system that is the basis for law in countries throughout North Africa, the Middle East, and Southern and Southeast Asia. Other examples of religious law may include traditional law in certain Christian countries, canon law, which became distinct from civil law in the Middle Ages, and so forth. I'd add another category, by the way, to these two. In certain parts of the United States, and this may be considered part of customary law, because you've got large populations of Native Americans living in areas that are somewhat autonomous of the U.S. federal government, called reservations. You also have Native American law, which is enforced in many of these jurisdictions, and I think that can be considered customary law. The book doesn't specifically mention that, but something that we often forget is that in the U.S. we're not just 90% English common law and the rest Louisiana. We have substantial areas of the U.S. where Native Americans who've lived here long before the Europeans arrived have maintained their own traditions, have developed their own legal systems, and operate somewhat autonomously of the federal government and the U.S. states with which they're associated. Now, within the common law system, you've got different categories of law. You have criminal law. Criminal law is concerned with individual conduct. A criminal action is individual conduct so morally reprehensible that the criminal justice system must prosecute. Criminal law is prosecuted on behalf of society, not the injured party. Criminal law, strictly speaking, is society's sanction against very evil, very bad behavior. It's not a system for compensating the victim for harm done. That is actually something that's more of the concern of a civil system. The civil system is concerned with financial awards to compensate injuries. You're not dealing here necessarily with actions that are morally reprehensible. You're dealing here with actions that just cost somebody something, that cause somebody harm. That harm can be quantified in economic terms. Therefore, the party causing the harm needs to compensate the party that has been harmed. It's an economic system. It's not a system of moral judgment. Being sued and successfully sued doesn't necessarily mean that you have done something morally reprehensible. It just means that the courts have decided you need to compensate somebody economically for a loss that you caused. It differs from criminal law in that the party injured must bring action. Action is not brought on behalf of society. Action is brought on behalf of the party injured, and the party injured is seeking restitution. Civil law previously meant the civil code in civil law jurisdictions. It now means a code regulating conduct between individuals. Civil law deals with the law between people. Now, regulatory law enforces standards of performance and conduct. Regulatory law is a case where an agency, typically part of the branch of the executive of the government, is charged with setting standards for behavior by individuals and corporations conducting certain activities. The Federal Communications Commission is a regulatory agency that regulates common communication media. The Food and Drug Administration is a regulatory agency that is supposed to ensure the safety of food and drugs and is given a rather broad mandate to research issues given the safety and to promulgate regulations that entities handling food and drugs need to follow. Common law system categories not the same as court-made common law discussed previously. Now, civil law. Civil law has certain categories to it. There's tort law, which deals with damages, assaults, batteries, trespass, negligence. It involves compensation for damages. Assaults, batteries, and trespass sound like criminal action. In many jurisdictions, you can be charged criminally for committing these activities, but you can also be sued civilly, and the injured party can gain damages from you for an assault, for a battery, or for trespass. There can be civil trespass suits where your trespass has caused damage to somebody's property. Contract law is where parties establish rules between themselves that they agree to governing their conduct, and where they, by forming a contract, enforce these rules for the court system. It's sometimes called privity, P-R-I-V-I-T-Y. Contract law is sort of human-made law. It's law that's made without an agency of the state. It's you and I can agree that between the two of us, we agree that we will regulate our business relationships, other relationships between us, and sign a contract agreeing to do certain things. And providing this contract does not violate any other sorts of law, any criminal law or standing civil or regulatory law, that contract is enforceable in a court of law. So in essence, contract law is a mechanism for private agreements to be enforced by the government. You'll run into contract law in the security field, not particularly often, but mainly when it comes to intellectual property, particularly software end-user licensing agreements, intellectual property agreements regarding the use of software and hardware, and so forth. Property law deals with the law concerning civil rights of property. And here it's mainly intellectual property and trade secrets. Security concerns are your own compliance with this. Attackers using breached sites to distribute illicitly obtained intellectual property goods. and so on and so forth. Also note that a legal definition of property must exist in order for a market to exist in that property and for a value for that property to be assigned. Something has to be defined as legally as a possession for it to actually have any sort of assignable value. Now, don't confuse a tort with a tort. We're not talking about a delicious dessert here. Tort law, which this is not covered in the book, by the way, is a civil wrong, a breach of civil law other than a breach of contract for which the law provides a remedy. It's an injury, or it's something involving property damages, typically a tort. It's a compensation for economic damages. You can get compensatory damage, which is the actual cost of the damage. Punitive damages are intended to punish culpable negligence. If the damage is caused by something that is negligence in the sense where you are culpable, then courts can determine that you need to pay additional damages in order to make you stop. And then there may be statutory damages. The tort law can be modulated in effect by the legislative branch of the government. Laws can be passed that establish how much in damages can be granted, can set caps, can set baselines, can determine that certain things can receive compensation, other things can't. So these can be established by law. They can be established by statutory law as well as by case law. Damages are awarded based on a preponderance of evidence, which is a less restrictive standard than criminal cases. So you can have to fork over a lot of money in damages for something bad you did when the level of evidence is not sufficient to convict you for a criminal offense. And this does happen sometimes. It seems like an oddity of the legal system. Somebody was declared innocent in a criminal trial and is then sued civilly for the damages caused by their alleged criminal action, and they're required to award the damages because the standard of proof in the civil system is not as high as in the criminal system. Why is this? Isn't truth the truth? Well, it turns out that in the criminal system, somebody who loses can be thrown in jail, can be in prison, can lose their liberty. And this is considered a much more valuable thing in our justice system than simply having to fork over a bundle of money. So the standard of evidence and the standard of proof to force someone in jail is much higher than the standard to force them to pay compensation, because your liberty is more valuable than your money. Now, there are basically two types of torts. There are cases involving negligence, where the harm results from a lack of due care, where you have to find fault. A breach of your due care duty resulting in economic harm. You were supposed to take care of something, you were supposed to do something in a professional, diligent manner, and somehow you did not. You did not follow the standards that are typically set for, due care. And as a result of that, someone was injured and you have to compensate the other party. A defense against this is you did follow standards of due care, you were not negligent, therefore even if damage resulted, you don't have to pay. You did your job as well as can be determined in a court of law, and therefore you are not negligent. There's another category called strict liability, and what strict liability means is you did something, a damage resulted, it doesn't matter if you're negligent or not, you still have to pay damages. And where you typically find strict liability, it's in inherently hazardous activities. Things like using dynamite to blast out the sides of mountains in construction projects. If a piece of that rock ends up damaging someone's property, ends up, hurtling through a window of an office building and costing thousands of dollars to fix, then that's strict liability. You don't have an opportunity to prove you weren't negligent because what you're doing is inherently dangerous to begin with. Now, going back to negligence. In order to establish negligence, you need to determine certain sorts of things in a court of law. First, you need to determine that you had a legal duty, that there was a duty existing. Secondly, you have to prove that this duty was breached. Third, the breach caused the damages. And then fourth, that the damages actually exist. You can't sue somebody unless you've actually suffered damages. You can't say, well, he's doing something I don't like, therefore I'm going to sue him. You have to prove in a court of law that you suffered monetary damages resulting from this other person's negligence. You have to prove that the damages were caused by their breach. You have to prove that they had a duty to do something and neglected that duty, okay? So it's everything from the party was supposed to do something, they neglected doing it in a proper way, something bad happened, and that bad thing caused you damages for which you need compensation. You have to prove each of those things in order to successfully argue a case like this. Now, in the security area, we're looking at damages, we're looking at civil law, we're not looking at violated criminal statutes, we're not looking at cases where somebody will end up in jail for doing something bad, we're not looking at regulatory violations. When you look at stuff like, say, HIPAA and GrammL Bliley, most of those are regulatory violations where you can be fined. We're talking about torts, we're talking about damages for compensation for an injury caused by negligence. One area that may occur that may be of interest to you as a security person is a so-called invasion of privacy tort, which is an injury to a natural person. Natural persons means corporations, even though they're legally persons, cannot suffer from an invasion of privacy. Only a flesh and blood person born of a human being can file an invasion of privacy tort. It involves an appropriation of a person's name or likeness, an intrusion on their private affairs, the publication of information that places the individual in a false light, or the disclosure of private facts about a plaintiff. And these typically are difficult cases to prosecute because most of the folks who are important enough to be in a situation where this occurs are already figures, in public view who have a limited ability to sue for invasion of privacy. But if you as a private individual, who is not otherwise in a public view, has this happening to them, then, you may have a case for an invasion of privacy tort. And again, we're talking about due care and negligence, and it is theoretically possible that negligence in terms of securing your own systems, if they contain private or personal information, could leave you open to this sort of legal action. Again, talk to an attorney, but this is something to keep in mind. You have to keep in mind, do you have a professional duty? Was that duty breached? And did somebody suffer harm for which they could be compensated? An invasion of privacy meets those. Another area involves product liability, and this is an interesting one because it's something that as a security professional you're not subject to, but as a security professional it's something that you wish was otherwise. In the case of most products, product liability means that, one, that the product will perform per its advertised or stated capabilities. If you buy, say, a toaster from a store and it does not toast bread as advertised, then, the promise made by a manufacturer of a product about its capabilities has been breached. In the case of an actual toaster, the harm is negligible here, but it would give you a legal cause to get a refund or to find in exchange for a working toaster. The other thing is product liability if the product is defective and results in harm. If the normal course of toasting bread causes the toaster to explode into flames and causes your house to burn down, then that may be a defective product, and you may have a case for suing the manufacturer of the toaster under the doctrine of product liability for compensation for the fact that his defective product led you to great economic harm. Now, where security professionals will rue the doctrine is software is usually, almost always in the U.S., an exception. It's treated as an information conveyance, as a book, and First Amendment protections almost always trump civil issues of damages and compensation in the United States because it's believed that freedom of speech is much more important than compensation in the case where someone may abuse freedom of speech, because if folks had to be worried about being sued every time they gave an opinion or stated something they believed was truthful, it would create an incredible damper on the free exchange of information and the ability of people to express opinions. So it's treated as an information conveyance, sort of as a book or a store of information rather than a machine. So the application of product liability to defective software has been limited. If you buy software and it does something horrendous, if you buy software that purports to be a secure web server and it turns out not to be secure at all, and you suffer grave damages because of the insecurities that you had no knowledge of, your chances of compensation to the tort system are fairly limited. Now, here's another topic that's kind of interesting, and I'm mentioning this more because it's very speculative. And, it's one of those things that technology people who aren't lawyers like to chat about and talk about. And, gee, maybe we shouldn't do this because if somebody hacked in our system and set up a server and used it to attack a bank, the bank could sue us for having bad security. And, maybe we don't want to get sued. And that's interesting speculative conversation, but I'm bringing this up in order to bring up some background into this whole topic, the topic of downstream liability, and also to warn you not to make decisions based on what I'm saying here or on what your colleagues who do not practice law in a particular specialty may say. Meaning, don't believe your folks in IT, don't believe the people you meet at the DEF CON conference or the people at SANS or anything like that. Talk to a lawyer. But there is this thing that's been talked about called downstream liability. Let's suppose you are an organization that doesn't have anything you consider really valuable and you're very lax about security. An attacker compromises a system of yours. Let's say you're a university and it's a research machine and the professor who's running the machine has a gazillion years of tenure and nobody can tell him what to do, so the machine isn't secure and you just have to live with it. Somebody compromises that machine. They then use that machine to attack banks, stock brokerages, huge corporations, causing incredible amounts of damages, bringing these corporations offline, stealing their closely held secrets, uncovering the formula for Coca-Cola, figuring out Dick Cheney's secret hideout, that sort of stuff. Since these targets who actually suffer harm are big companies with large legal staffs, can they feasibly sue you for providing the attacker with an intermediary for attacking their target? Can they claim that you were negligent in suing your system, and your negligence opened the door to somebody taking over your systems and bringing down theirs? Why would they do this sort of suit? Why would they sue you? Why wouldn't they go after the person who's the attacker? After all, they're the one really causing the damage. Well, the motivation is the attacker might be outside the reach of law, or the attacker might be, in some cases, somebody who doesn't have a whole lot of resources. I mean, there have been cases where it's been, some 14-year-old, in a family with modest means who's actually done these horrific attacks. You can't sue them. Either you can't get to them because they're outside of the reach of law, they're outside of this country, their identity is concealed, the authorities in other countries don't believe in our legal system and aren't going to allow the suit to proceed, or the attacker has such a small amount of assets that even if you attach their earnings until the year they die, you still wouldn't get a whole lot of money. However, you, as the party who was breached, has deep pockets. You're a university. You got a lot of money. You've got endowments and so forth. The attacker, this 14-year-old kid, doesn't have any money. If big megalith corporation suffers huge damages and wants to go after somebody, who will they go after? The kid whose parents maybe have a house with a mortgage on it, or you, a university with many, many millions of dollars in assets. They'll try to go after you. Now, again, this is somewhat hypothetical. Downstream liability attacks have been talked about, and I have to say that for the most part talked about by folks who aren't attorneys. But you may correct me if you find otherwise in this class. I haven't seen any real evidence that one has been successfully conducted, at least not within the public view. There's an interesting precedent for this sort of thing, and this is a funny sort of case that technical people like to talk about. It's not mentioned in the books, but I'll just mention it to you as a way of how the legal system works or may not work. There's a case that's often referred to as the T.J. Hooper case. T.J. Hooper was a tugboat in the Great Lakes. This occurred in the 1930s. The tugboat sank because of an unexpected change in the weather. There was no loss of life, thankfully, but it had some very valuable cargo that ended up at the bottom of the Great Lakes and could not be salvaged. The storm came upon the ship rather suddenly, but one of the arguments made in the court case involving compensation for the damages for the loss of cargo, was that had the ship had a radio, they would have been able to know that the change in weather was coming, and they would have been able to dock safely. But the ship did not have a radio, therefore the ship captain and the shipping company were negligent. Now, the argument was made that in the 1930s, for ships on inland lakes to have a radio for this purpose was very unusual and very rare. It wasn't a commonly accepted practice, therefore why expect us to do it? The decision of the courts were different. The decision was the standard of care and liability may exceed accepted industry practice. What this means is because nobody else had a radio on board their ship, doesn't mean that you can get away with that as a defense in a court of law. Or more legalistically, satisfaction of common custom may not preclude liability. Now, as a security person, you'll jump to the conclusion that, oh, this means that just because we're just as secure as our competitors across town means that we can still be sued, because just because everyone else has bad security doesn't mean that we're protected. We have to have good security. We have better security, so we don't end up like the folks owning the TJ Hooper having to fork over a lot of money in the event we got hacked. Now, the flip side of this is, number one, court cases can often be very specific. In fact, in this case, I've actually read some analysis of it where they make the argument that the precedent of this case only applies to maritime law. Doesn't apply to anything other than, ships at sea and in inland lakes. So TJ Hooper doesn't really, in that argument, doesn't mean a lot in terms of defense against downstream liability. The owners of the TJ Hooper may have had to pay out a lot of money because they didn't have a radio on their ship and couldn't get away with claiming as an excuse or reason that no one else had one either. But that doesn't mean it applies to your company and your poor security practices that are just as bad or no worse than anyone else's. Just because this case went this way doesn't mean that your case will go that way. The other thing to keep in mind about civil suits and tort laws is there's two parties involved, and that the party bringing the litigation can be subject to interrogation about their security practices as well, and that for one party to sue another claiming that the defendant had very poor information security is opening the plaintiff up to have their security practices examined as well. It's like, well, you're claiming this other party allowed you to get hacked in because they had poor security. Well, we're going to demonstrate your security was just as bad, and the case is a moot point. So the reality is, there's a lot of risk involved in actually suing somebody for damages, unless it's fairly clear cut. And in the case of information security, companies tend to be rather skittish about having to open their own practice up to examination in the court of law in the hopes of maybe perhaps getting, some damages from a party that injured them. So there's just both the legal issue as well as the practical issue. The legal issue with tort law is, can you legally claim compensation? The practical issue is it worth our while, and will the process end up costing us more in real dollars as well as soft costs than it's worth? A lot of cases folks will just settle out of court and not even bother with bringing litigation. Now we're talking about property law. Property law is another aspect of civil law. There are 4 types of property, intellectual property, that are of concern in the world of information security: patents, copyrights, trademarks and service marks, and trade secrets. Patents are designed for protection of industrial processes, for protection of innovations in machinery and engineering techniques. They're not intended to patent scientific facts or mathematical proofs. And this is why the status of software patents is ambiguous internationally. Whereas the United States may award somebody a patent for software under the theory that this is actually the codification of an industrial process, in other countries that software patent may not be honored or recognized because software is considered a system of mathematics, hence is part of the law of nature and not something that is subject to a patent. Patents generally last for 20 years for utility patents. There are things called ornamental design patents that are only 14 years. Patents are not renewable. Once a patent ends, it ends. Patents are difficult to obtain. You've got to prove that the innovation is new, useful, and non-obvious, and the process of obtaining a patent is very costly as well. You need to research prior relevant patents as part of this process. It protects the idea itself behind the process or the engineering innovation. Hence, it's solid protection against re-engineering or claimed independent invention. It's possible for a party to infringe on a patent without even knowing it existed. Patents are rock solid in that case. Ignorance is no excuse. It's I own the process. If you're using it and haven't paid me the fee I required, then pay up, and I don't care if you never heard about us before. Now, copyrights are a different thing. First, they last a lot longer, for 75 years, and are renewable. They're fairly easy to get. The mere act of publishing something gives it an implicit copyright, though to sue for a copyright, I believe, requires that you registered the published item with the Library of Congress. Protects a form of expression rather than the idea expressed. It's not a protection against re-engineering. You can copyright software, but if somebody can glean the functionality of the software and the algorithms behind it and rewrite that software independently of its own unique coding, then the copyright doesn't apply. There's something called fair use, and that's intended to protect academic research and to provide for First Amendment issues. You're allowed to study copyrighted materials, quote from them, research and analyze them, and use them within the public sphere of argument and public speech as part of your First Amendment rights and to protect academic research. Fair use is fairly circumscribed. And, for the most part, if there's the slightest taint of commercialism or money-making involved, fair use does not apply at all. Computer programs are specifically allowed to be copyrighted under Section 17, the U.S. Code 101, as of 1980. Copyrights give the author of the work or whoever bought the rights from the author the right to determine who may copy that work or not copy that work. Trademarks and service marks have to do with distinguishing graphical elements, design elements, wording, phrasing, sounds that mark a particular business product or a business service. A trademark applies to tangible entities. A service mark applies to non-tangible entities. Trademarks apply to, say, the design of an automobile may be trademarked. A service mark is a logo, say, of a law or accounting firm, maybe a service mark. Trademarks and service marks have indefinite lifespans as long as the owner of the trademark or service mark continues to enforce them. This is why, if you use a word describing a trademarked product in an informal online forum without recognizing it's trademarked, a representative of that company may, give you a little nastygram saying you understand this is a trademark term. Terms that where the trademark haven't been enforced have passed into common vernacular and become part of the ordinary language and have lost their force as a branding of a business and as something that establishes a business's identity. The term Kleenex as facial tissue is one of those that may have entered the public domain just through common use. What the purpose of trademarks and service marks is all about is to help a business establish their identity and to make sure that competitors don't mislead the public into thinking that their business is the same as the other one. If you're an old-time LA person, you may remember there were a lot of hamburger places in LA that serve variations of a very famous chili laced hamburger that would call them things like Tony's Hamburgers and Tammy's Hamburgers and even Tawny's Hamburgers. You don't see those anymore because the original Tommy's Hamburger at Beverly and Rampart got cracking in terms of violation of their own trademark and service mark, and Tammy's Hamburgers, using the same color scheme and the same identical branding, a slightly different name, were put out of business. Last category of intellectual property here is trade secrets. They are secrets. They're not published. They're not known to the public. That's what makes them secrets. They have a lifespan as long as you can legitimately keep them secret. Lifespans can run centuries. The company, what is it, Zildjian, who has a certain type of metal they use for their percussion instruments. That metal is a trade secret that's been kept by that company for probably a couple of hundred years. It's protected by being a trade secret. It's commercially valuable information. Owners must take reasonable steps to protect the information in order for it to be recognized as something by the courts and by the legal systems as subject to trade secret protection. Trade secrets recognize the right of businesses to control knowledge used in a new technology and to prevent competitors from obtaining that knowledge improperly, from, say, bribing an employee or hiring somebody away, tell me about the secret formula for their magical product and, we'll make a knockoff of it and make a mint. You can't do that. Trade secret law is based on a long history of court-made common law, of case law involving civil damages and compensation for violating trade secrets, but it was codified in the Uniform Trade Secrets Act of 1985. It's traditionally been a civil tort, but it has recently, theft of trade secrets has been criminalized, specifically federally in 1996 by the Economic Espionage Act. You can now, by violating trade secrets, by unlawfully trafficking in them, get sent to prison under this law. Traditionally, it was a tort law, but you're also now subject to criminal prosecution in many cases. Software licensing combines some of these. Software licensing is a combination of contract law, copyright law, and in some cases patents. Violation of software licensing is a huge exposure for organizations. Beware of the helpful IT person who just installs the latest software on every employee's PC, whether they've got a proper license to have it on or not. This will put you under a great deal of liability. Large software providers do not have a sense of humor about this thing and will seek damages if you misuse their product in violation of their licensing terms. Licensing terms are typically enforced through master agreements or end-user licensing agreements called click-throughs, shrink-wrap agreements so far. And sometimes they require that you have proper software inventory management. You have to be able to provide information on how many of product X you've got installed, how many people are using it at any given time, if it's provided, on a network server of some sort, and so on. Supporting license compliance often requires assistance from information security staff. This is something that IT security people often have to help with, is license compliance. It's not really security per se, it's more inventory management, asset management, but security people get stuck with this, probably because it's really boring and the security people are the only ones who will do it. There are different types of licenses out there. The book mentions several. Shareware, freeware. Freeware means it's absolutely free. Shareware means you get a trial version for a small amount of money, you get the full version. Commercial license, buy this. And then academic licenses, which are restricted for the academic environment for purposes related to instruction. Make sure that you don't use something licensed in an academic environment in a commercial environment. Make sure that you follow the proper restrictions of even the shareware you have. Just because you download it for free doesn't mean you can use it as you wish. And then the last thing I want to mention is that freeware also includes what are referred to as open source licenses. Open source licenses tend to be very free, both in a sense of not costing, as well as a sense of providing you a license to the source code for the software with very limited or no restrictions on what you can do with that software. It gives you the freedom to examine the software, to change it, to modify it as you see fit, which is not something you typically see in commercial products. I've included on the class websites a number of links to information about open source licenses. As a security professional, it would behoove you to know something about them, know something about the GPL and about the BSD license, because many of the products you work with fall under these licenses. Products like, say, Nessus, Snort, even though those two products are partially commercial now, Nmap, various security monitoring and management tools fall under an open source license. Know what these licenses let you do and don't let you do. Privacy is another issue. I discussed it a bit within the context of invasion of privacy tort, but it's an issue all on its own, and it's an international issue because the European countries in the Organization for Economic Cooperation and Development have their own set of standards for privacy. And if your company or you do business in Europe, you have to keep in mind that the standards they have there are much more restrictive than the ones that you're familiar with here in the United States. They limit collection of personal data. It must be collected for relevant purposes. You have to tell the folks collecting, why you're collecting it, what you're going to use it for. It requires consent, and you have to have reasonable security standards. The OECD is an international organization of 34 countries founded in 1961 to stimulate economic process and world trade. It's an organization that was started as the Organization for European Economic Cooperation after the Second World War to help administer the Marshall Plan. So, it's a union of countries that cooperate economically at an international level, focusing on Europe, and it's somewhat a Eurocentric organization. The OECD privacy regulations may have the force of law in many European countries. Again, talk to a lawyer, because the laws in Italy versus the laws in Germany versus the laws in the Netherlands are all different. But the thing to keep in mind is that laws in Europe regarding privacy of personal information may be different than the US, and it's something that you need to get some advice on how dealing with, because you may be completely compliant with US law and run into serious trouble in other countries. Employee eavesdropping. You're a security professional. You look at network traffic. You're looking for malware, potential hackers, and so forth as part of your intrusion detection system. You may see something that looks like an attempted intrusion and start capturing packets and examine those packets to see what's in them. Keep in mind that by being diligent in managing your network and attempting to get to the bottom of security issues, that under certain jurisdiction you may be involved in eavesdropping, and you need to be careful about how you handle that information. Laws vary depending on the country. The thing to keep in mind in the U.S., the Electronic Communication Privacy Act of 1986 is relevant here. It generally prohibits eavesdropping or intercepting message contents. You can't access information in transit or stored communications, but there are exceptions. Corporate systems and providers, if you're an internet service provider, if you're running the network for your company, and in the ordinary course of businesses where employers can intercept communication. The key here is ordinary course of business. Ask your lawyer for a definition. You may find that you are suddenly suspicious about somebody in a company and decide to suddenly start eavesdropping on their network traffic because you think they're up to no good, and that may not qualify as ordinary course of business. Talk to a lawyer. The exceptions are consent. You can intercept communication where one party has given consent. If you're the help desk and someone's computer is not properly accessing network services, you may have explicit or implicit consent to capture their traffic to see what the deal is with the network communication. And in stored communications aren't as stringently protected as in transit communications. There are also state laws and court-made common laws. We talked about invasion of privacy torts, which is a court-made common law, and there are state laws dealing with eavesdropping as well. In certain states, both parties have to consent for eavesdropping. In other states, only one party, for example. Talk to a lawyer, but bear in mind that diligently doing your job, examining traffic flows to figure out the security status and the network status of your organization or folks you're trying to help. Make sure that in the process of doing that, you don't run afoul of laws governing privacy and eavesdropping. Now we're going to get into a couple of the landmark United States legal federal laws regarding computer security, or laws that impact computer security. These are laws that were formally discussed in some depth in older versions of the CISSP study text that apparently aren't in the text now. I'm not sure if it's because it's not relevant, or it's because the folks ISC Squared is trying to make the CISSP more internationally relevant and didn't want to focus so exclusively on law in the United States. But for the purposes of this class, I think it's important to know about these laws. First one is the Electronic Communication Privacy Act. Give you a nice bold yellow there. It generally prohibits eavesdropping or intercepting contents. Oh, hey. We've already gone over this. I guess this slide is a duplicate. But anyway, Electronic Communication Privacy Act, yeah. We know about that. Don't eavesdrop. Health Insurance Portability Accountability Act, or HIPAA. Passed in '96, it was part of a law that was meant to encourage insurance companies to rely more on electronic interchange of health data and health insurance information in an effort to make health insurance run more efficiently, more cost effectively in this country. folks realize that, hey, if you're going to make doctors and hospitals and insurance companies communicate electronically, that you better make sure they do so securely, because those patient health records aren't locked up in a doctor's file cabinet anymore. They're existing on service and in transit across networks, and you better make sure they're secure. Otherwise, you're going to have a disaster when, folks' health information gets disclosed on a massive scale. So, in addition to establishing standards for the electronic exchange of data and insurance information, it also requires protection of personal health information, including training, physical security, and logical access controls, including controls over read access, things like logging, who has looked at, when, at what time, individuals' personal health information. Anytime a nurse or some other medical staff looks at your records, it should be tracked. It's not just of concern for medical establishment. Any entity processing health information, like insurance claims, your employer may be in the construction business, but if they're self-insured or they're involved at all in the processing of insurance claims, and this includes stuff like workers' comp, by the way. It's not just your own private health insurance policy. Anything involving personal health information is covered by HIPAA. So it casts a pretty wide net. A lot of organizations that you think have nothing to do with health insurance have to follow HIPAA standards. Gramm Bliley. This is another act that was set up to rationalize an industry. It was actually set up to open up the banking industry from the Depression-era restrictions on what banks could and couldn't do. And one result of that opening up was, again, the realization of you're opening things up, you're allowing banks to acquire brokerages and insurance companies. Do you want the brokerages and insurance companies to be privy to people's account information, their credit card transactions, their checking account transactions, and so forth, what their balances are, etc.? There's a lot of sensitive information there. There's records of what you're paid, medical reimbursements, what you had to pay in taxes, penalties, if you've had, wages garnished or something, maybe, if you've had a judgment against you. There's a lot of interesting stuff that's part of banking records that, is pretty sensitive. And banks in the past were trusted with this because all they could do was hold your money. But now that they're in other businesses and they can become an effectively, insurance companies and stock brokerages and whatever, shouldn't this information be safeguarded more? So Gramm Bliley, as part of the change in regulating the financial institutions, created new regulations addressing privacy and security of customer information. And these specifically require ensuring the security and confidentiality of records and information and protecting against threats or hazards. So it requires protecting information and enforcing security. And then again, just like HIPAA, it's not just of concern for financial institutions. Any organization that provides financial services may be affected. A difference between Gramm Bliley and HIPAA is HIPAA in some cases requires certain specific controls over information. In certain cases, the regulations require certain things be encrypted under certain circumstances. Gramm Bliley isn't so specific. It provides some general standards, but it's still something that requires a certain amount of security, and it's something that information security people need to address in appropriate organizations. Part of your controls must be compliance with this. There are also regulatory security standards, standards that mandate particular specific security practices and certain levels of security, and these tend to be levels mandated of other government agencies. The two biggies here are the Computer Security Act of 1987 and the Federal Information Security Management Act, I believe, of 2002. The Computer Security Act of 1987 outlined minimal acceptable practices for protecting sensitive information in federal government computer systems. It's information that is sensitive but not classified. Classified information is covered by national defense criteria. That's your secret and your top secret stuff. This is things like, health information that's the Center for Disease Control may have, various welfare and benefits programs that contain personal information about clients of these programs, perhaps information programs that benefit college students may contain information about student grades and records, etc. This legislation effectively created the sensitive but unclassified category. So things like, say, if you're a federal employee, information about your health insurance claims are covered by this, as well as perhaps by HIPAA. It gives the National Institute of Standards and Technology responsibility for drafting standards and guidelines in this area, whereas the NSA, the National Security Agency, has responsibility for defense-oriented data. For the classified stuff, NIST covers the non-classified stuff. It requires security plans for all federal computer systems containing sensitive but unclassified data, and it mandates periodic information security training. So it created a whole category of federally protected information that is not national security related, that requires special controls and special plans for its protection. A story behind the origin of this act is that at the time the act was passed, right prior to it, the executive branch of the government, President Reagan's branch, was attempting to classify information that historically hadn't been considered national security related. Congress was in the hands of the opposing party and didn't particularly like the notion that information, say, about federal government contracts and personnel records and so forth, could suddenly become secret or top secret, but decided they did have a point that this information has some sensitivity, and passed this law as an attempt to forestall that information being formally classified under national defense, intelligence, and security criteria. The Federal Information Security Management, or FISMA, was passed in December 2002, part of the E-Government Act, and it requires agencies to develop information security programs, and it requires reporting to Congress and the OMB the effectiveness of these programs, and also requires the Office of the Inspector General, the OIG, to assess the effectiveness of the programs. This is it in a nutshell. Now, FISMA, there's a certain controversy about it, particularly folks in SANS. I've noticed on the mailing list and so forth that they historically have tended to think that FISMA was not a very useful program, that what it does is creates a paperwork drill associated with compliance, rather than encouraging federal agencies to take realistic steps to improve their security, that what you end up is a lot of paperwork, a lot of documentation of risk analyses, security plans, procedures, and policies, but the systems are still just as easy to break into as they were before, and that perhaps this law should be modified so that the practical implementation of security is emphasized more than the appearance of regulatory compliance. And that's just sort of the controversy about FISMA. Is in some circles it's considered a paperwork drill rather than an effective security measure. My personal attitude is requiring people to actually document this stuff is an important first step. Even a paperwork drill has some use. If you don't even have that level of security, then you're never going to have a reliable technical security architecture. That's just my opinion. Now we're going to go a bit into evidence, and this is covering stuff that's, related to investigations and so forth. And this, again, is stuff that isn't in the book, but you may want to know. Evidence are the facts that are brought up in a court of law that can be used either in a criminal or civil case that establish a position one way or the other, establish either the liability in a civil case or the guilt in a criminal case. The types of evidence are as follows. You can have direct evidence, which is called to prove a specific fact. Circumstantial evidence, which is direct in terms of proving a fact, but you have to apply a chain of reasoning to that fact to get to the place you want to get to. It's like X happened, therefore Y, therefore Z, therefore, Your Honor, he's guilty. That's circumstantial evidence. Direct evidence is X is true, therefore he's guilty. Judicial notice is an acknowledgement of the obvious. Sun rises every morning, that sort of stuff. So that's the types of evidence. Evidence can take different forms. You can have oral evidence. Somebody stands up in front of the court and testifies. That is either direct, I saw, I witnessed, I experienced, or I did, versus hearsay. I saw somebody do something, I heard them say something. Hearsay is problematic because in hearsay, one party is attesting to a third party who's not present as far as what they did, and you can't cross-examine the party that's not there. This is why hearsay is bad. Oral evidence, you're always subject to cross-examination. Attorney asks you questions and tries to determine whether you're telling the truth, or more commonly, if you are telling the truth, what does that truth mean? If you're saying, I heard Joe Blow say such and such, and Joe Blow isn't available to be interrogated, then you lose an important part of the courtroom experience in terms of proving that the meaning of that particular statement. There's documentary evidence, which uses a document to prove a fact supported by the contents of its document. There's real evidence, which is visiting a crime scene or a reproduction of it. I brought to mind the reproduction of the Unabomber's cabin that was reconstructed for the sake of the jury in Sacramento, California. That is a form of real evidence. And then there's expert opinion, where you have something where you need somebody who is an expert in a particular area to help the jury make a decision about what facts mean. Expert opinions are based on hypothetical situations described by an attorney by counsel. An expert lends their opinion to the likely result. It's not really a form of evidence, but you're assisting the judge or the jury in developing a line of reasoning. You have somebody who knows a subject matter very well, and they can say, well, in my opinion, if X happened, this means Y. In my opinion, I very rarely see circumstances where somebody does such and such because they typically have, as a matter of industry standard practices, this type of security control is a type of expert opinion. Generally, you're not directly addressing the facts, but you're addressing hypotheticals so that the jury can think about this stuff. Now, computer records are actually a form of hearsay, because a computer record is a recording, actually sort of a document, a ledger or a document, attesting to what somebody else did when that somebody else is not necessarily available to say whether I entered this transaction or typed up this document in the word processor. They're considered a form of hearsay. Hearsay is generally not admissible, except under some conditions. Turns out computer records, though, follow under one of those conditions under an exception. There is a federal rule that if a record is created and maintained in the ordinary course of business, meaning you do it as part of your day-to-day run of business, and it's made at or time the event is recorded, it's a regularly conducted business activity, it's not something unusual, and you make it a regular practice to keep this particular record, and it's kept for a business purpose, not just for personal curiosity, then it's admissible, it's trustworthy. Again, this is one of those ask your lawyer thing, but as a person working in information technology, you may want to think about this occasionally and, know that, if you don't normally record, say, audits of transactions or have an intrusion detection system and decide to turn on auditing or collect network traffic using a brand new IDS just because you think somebody's doing something suspicious, it may not be a regularly conducted business activity and not a regular practice. If you start doing something for purposes of proving a specific individual is doing something wrong, you might have trouble getting that admitted, or it might get admitted under sort of a cloud. Again, talk to an attorney, but it's better to do things conservatively and do things the right way than to cast doubt on these sort of things when you actually need them. Best evidence, you can't use a photocopy, and you need somebody who's a custodian who can testify as to the reliability of evidence. We've talked about custodians in the context of information owners and information custodians. Information technology is typically a custodian of data, and in a legal sense they're a custodian in that they may be called upon to testify as to whether a particular system reliably records data. If you're using computer records as evidence, you need to demonstrate chain of custody. The record was accurate when it was made. Who handled the record up to the time it was introduced as evidence must be able to demonstrate chain of possession. You can't say, and for 2 weeks I don't know where this thing was, but then it suddenly appeared somewhere, because that looks suspicious. It looks like somebody may have doctored this, may have made it up. You need to indicate that, yes, we have a system that documented attempted scans against our firewalls and kept records of those, and those records are burned to write-only media, and they were stored in a locked cabinet, at which point they were picked up by a trusted courier and kept in the courier's vaults, and they were retrieved from the vault, by myself with so-and-so witnessing them, and here you have here. You must demonstrate chain of possession. Discovery is a process of prosecution making evidence available to defense before going to trial. It's trial, not trail. What one side knows, the other side has to know. Whoever is prosecuting a criminal has to make the criminal's defense attorney privy to whatever facts they're going to introduce in the court. You cannot blindside the other counsel, otherwise you will have problems. Don't hide something in the thought that you don't want the other guy's attorney to find it, because that may get you in trouble. Don't hide things from your own attorney. Absolutely. Now, in certain cases, particularly when you're dealing with companies, you worry about trade secrets, about proprietary facts and so forth. You can have a protective order put into play during a trial in order to limit the use disposition of evidence in order to protect proprietary or trade secret documents. So our legal system has ways of protecting stuff. Just because you sue somebody for something doesn't mean that everything that was formerly a secret within your company has to be revealed in a court and end up in the next morning's press. Yes, it does have to be revealed in court, but you have ways of protecting it from unlawful disclosure. Forensics is the use of science and technology to investigate and establish facts. We have this interesting web page here for the Association of Computer Investigative Specialists for more information. Forensics is a field that is actually booming right now. If you folks are looking at careers in computer security, I would suggest getting into that field. I have to admit it's not a field that I personally have a lot of experience with, so most of what I would be talking about in this class is secondhand. But, knowing the handling of and proper examination of computer records and computer systems is very challenging, both from a legal point of view as well as a technical point of view. If you're examining, say, a hard drive on a suspect system, the evidence you're trying to find, may have been wiped, may be hidden in all kinds of strange places in the file system, may be hidden in unallocated blocks in the file system, and a good forensic specialist knows where to find this stuff. You really get into the bits and bytes here when you're looking at computer forensics. Now, in the process of conducting an investigation, here are some general rules, for probably the 15th time. I'm not a lawyer, but this is stuff to keep in mind. You document everything you do. You keep a notebook. You don't think, well, I'm going to write it down later. You write it down now. If you suspect your system is being broken into by an attacker, you don't use that system for handling your investigation. You assume that your email is being read by the attacker. You assume that your phone switch or voice over IP system is being eavesdropped on by the attacker. You meet people personally. You use an out-of-band system. Maybe you trust the cell phone system under certain circumstances where you don't trust your own internal phone system. Maybe you can send text messages. Maybe you just meet face-to-face. Be aware that you might document damages for insurance purposes. Even if you don't go to trial, you may have to file an insurance claim for the damages resulting from the computer attack, and that the results of an investigation may be used in civil as well as criminal cases. Just because you don't think this is something where you can prosecute somebody, they're in a foreign country, and you figure there's not any chance at all that you'd be able to file criminal charges, there still may be civil charges, and you still may need to file an insurance claim. Make sure you follow proper procedures anyway, even if you personally suspect a legal prosecution is way out in left field. Make sure you have a crisis management team. Be aware that prosecuting someone is very time-consuming, both as investigation as well as subsequent trial. If you go ahead with prosecuting somebody, bear in mind that it will be very time-consuming for your own organization. The courts and law enforcement recognize this now, and will do their best to make sure critical staff are not pulled out for indeterminate amounts of time. But even at its best, there is some burden. And then the other thing to realize is when you bring in law enforcement, they run the show. If you get to a point where you have to call the police, the FBI, the Secret Service, they're in charge. Deal with it. A couple things here about incident response. The book covers this a little more. I actually cover it somewhat in my first class, 41771. And, folks who are interested, we can review that material. But incident response covers response capability, response and handling, the recovery phase, which is how do you bring your systems back to normal? How do you restore systems that have been compromised? In the worst possible case, which is most cases, you assume that the attacker has planted a rootkit, and you have to wipe the hard drive and restore from the last known good backup, which may be from quite a while previously. And in conducting digital investigations, computer forensics, that interesting combination of legal and, very down in the bits and bytes hardware knowledge. You analyze software for evidence of compromise, looking at things like, the operating system, user land software, other programs, as well as audit logs for evidence of intrusion. Again, this is just a very brief run over of incident response. The book itself has a little more detail, and there are a lot of fascinating resources. This is, very interesting and very exciting area of computer security to be involved in. And if you're interested, there's a lot more information out there about that.